There's no specific offence of domestic abuse or domestic violence. It can constitute a number of different offences committed in a domestic environment. So, for example, various forms of assault or common assault, allegations of controlling and coercive behaviour, and relatively new offence of non-fatal strangulation and non-fatal suffocation. Allegations in relation to domestic abuse are now being prioritised, and investigations are on the increase. And we see new offences have been created, and time limits in relation to the investigations of some offences have also been increased. The Domestic Abuse Act 2021 has dramatically altered the landscape for the investigation and prosecution of domestic abuse offences. So we find that there are more offences capable of being investigated and a greater amount of police resources being put into the investigation and prosecution of these offences. Coercive behaviour can involve acts or an act of violence, threats of violence, intimidation, coercion that can frighten, harm, or intimidate or isolate a complainant. Controlling behaviour can involve an array of acts that can make an individual feel isolated or that they've lost their independence. The individual may have no access to support. They may feel that their daily behaviour is being regulated. There are 4 elements to the offence of controlling and coercive behaviour. Firstly, the behaviour has to be controlling and coercive. Secondly, the individuals have to be personally connected. Thirdly, the behaviour has to have had a serious effect upon the complainant. And finally, the suspect has to have known or ought to have known that it would have had such an effect upon the complainant. Non-fatal strangulation has been a criminal offence since 2022. There are in fact 2 offences: as non-fatal strangulation and non-fatal suffocation. And it involves essentially a deliberate act that affects another person's breathing. And the maximum sentence for the offence is 5 years imprisonment. Following a police interview, there's an awful lot that can be done on behalf of someone who's under investigation in relation to a domestic abuse allegation. The first thing to do is to work out what areas of the prosecution case can be contradicted or undermined. And it's at that point the defence would then go on the front foot and instigate pre-charge engagement with investigators. Following that, we would then build up representations that could be made to the police against a prosecution taking place. In other words, representations against charge. We would then argue that the charging standard contained within the Code for Crown Prosecutors is not met, either because there is not a realistic prospect of a conviction, or that a prosecution is not in the public interest. What we're likely to do is draw to the attention of investigators material that will undermine the prosecution case. And this list is not exhaustive. It may include text messaging, email, other electronic communication. It may involve social media activity. It could include financial transactions and banking activity. There could be third-party material. There could be material in the family proceedings. It may be necessary to speak to witnesses, family members, friends, and so on. The list goes on and on. We'll frequently draw to the attention of prosecutors a reason, potentially a motive as to why an allegation has been made. Because often allegations of domestic abuse are made at the end of a relationship when emotions are running high, and there can be all sorts of issues that are flying around between the parties, whether that relates to children, finances, new relationships. And that's something that we feel it's really important for the police and prosecutors to fully appreciate, so that the only prosecutions that take place are the ones that should be before the courts. A decision to prosecute someone is made if the charging standard is met, and the charging standard is contained within the Code for Crown Prosecutors. And under the charging standard, for a prosecution to take place, there must be a realistic prospect of a conviction, and a prosecution must be in the public interest. And it's the role of defence lawyers during the pre-charge stage of the case to persuade investigators and in due course prosecutors either that there is not a realistic prospect of a conviction, or that a prosecution is not in the public interest. Absolutely. Not only do we represent people during the pre-charge stage of the case, but we represent individuals who come to us having been told that they are due to appear in court. The level of experience at Olliers is substantial. We have a large team of specialists with huge levels of experience of dealing with domestic abuse allegations. So the message is simple. If you come to Olliers, we will ensure that the right lawyer is allocated to the right client every single time.